Okay, just so it's on the video for everybody, we have 3 more classes where everybody can participate for free. There's this class, next week's class, and the first class of next month. The mock trial will be on the first class of next month. That gives us 2 more workup sessions tonight and next week to get ready for that. Okay? Hopefully everybody did the reading I gave out in the last class. And they took a look at all the documents and all the stuff that I gave to you. And hopefully you came up with something useful and can do something with it. So, that said, did anyone do the homework? The assignment was to take the paperwork from Jane's case and study everything that was filed by the prosecutor and everything that we filed in response to the paperwork by the prosecutor, as well as our own motions to set aside the complaint. There was multiple reasons for doing that. One, it was to test whether or not you understood what the language used on either side was meant to do and why it has to be done that way. The other was to see if you understood the arguments and also whether or not there may have been a better way to make them. In other words, the purpose of this was for you to see an example of what they do versus at least how I do it in response, and see if you could come up with something on your own that was equal to or better. That was the assignment. And then you're supposed to come back to this class tonight with questions regarding what you came up with during that assignment.
Well, I do need help with one particular item. I still haven't heard anything back from the judge as far as his response to our motion that we filed. So my question is...
Well, the judge is not going to rule on the motion on his own. You still have to set a motions hearing and get him to rule on it there.
Yeah, we did the motions hearing. The pre-trial motions hearing back on the 30th of May.
And he didn't rule on it then?
No, he didn't.
What did he say?
I said, the prosecutor said, well, this needs to move to trial. And I'm like, well, I had made the arguments, everything that was in the motion. And he said, well, I'll consider ruling on it.
You take it under consideration.
Yeah, he'll take it under consideration, but he never made any ruling.
Well,
so when I go to my hearing on Monday, which is basically, I guess, the appearance to schedule the trial.
Announcement.
Yeah, the announcement. So can I still make an argument there? I feel like I can.
I don't see any reason why not.
Because at the
very least, you can ask him, Judge.
Have you read my motion?
Yeah, so far I've heard absolutely nothing from this court about my motion.
Yeah. So, and no one's responded. And not even the prosecutor. He just responded there, well, that's why we have a pre-trial motions hearing. Okay. But then again, no one's really read through it entirely to determine which part of the law is, that they're going to say that my motion needs to be denied or can be granted. So what the heck?
Well, this is why you keep a timeline of everything. Make sure you make a timeline that shows every time you file a document. Hang on just a second. I'll show you how I used to do it when I first started doing this, if I can find the sheet. I know I've got it somewhere, but let me see if I can find it.
I mean, basically, they know I'm pro se, right? And to me, what they're doing is the same exact thing that they did to me at the lower court, which was deny my motions and not give me any elements of law as to how they came up. with that denial? No facts of law given, oh, well, this complaint is complete and it has all the elements. No, it doesn't. Number one, the police officer acting as, the person that is making the allegation and then not certifying under penalty and perjury their own
No, wait a minute. Again, okay, stop. First off, that is not a requirement of a criminal complaint in Texas. I have told you that how many times now in this class. Criminal complaints do not have to be signed under penalty of perjury. The statute very clearly says they can sign it. I have reason to believe and do believe. And there's good reason for that. As an example, let's say that you have a good friend who's getting beat by her husband, but is afraid to report the husband to the police for the beatings. But you, as a third party, see the bruises, suspect what's wrong, and you go down and file a criminal complaint against the husband on her behalf, saying that you believe she's being physically abused or domestically abused. You sign it, I have reason to believe and do believe, and then you cite the reasons why you believe all this has occurred and that a crime is being committed of this nature. That's why criminal complaints can be written and signed that way, so that the person does not have to be a first-hand fact witness to sign it. Okay? It is the sworn statement that has to be signed under penalty of perjury. If they were following the law correctly, this is the order the paperwork would be filed in, and what is actually supposed to occur based upon that piece of paperwork. Someone files a complaint, reason to believe and does believe. They don't know, but they have a good cause to believe something's wrong, and this is what they think it might be. That gets filed. It can be filed with the prosecuting attorney, it can be filed with a magistrate, it can be filed with a law enforcement officer. But either way, the first thing that should happen, based on the complaint and only the complaint, is that an official investigation of the allegations should be opened. Once the investigation has been performed and a conclusion made from the facts and evidence gained, they either then write up a sworn statement under penalty of perjury saying, after investigation, I have found the following evidence that leads me to have good cause to believe that this person has committed this crime, and I would like to request a warrant for their arrest. Okay? That's the probable cause affidavit that goes in for the warrant. That's the sworn statement.
But see, I never had a probable cause hearing. I never had.
That, but
and so there you go.
That's beside the point here at the moment. We're talking about the order of the paperwork and the process that should follow in along with that piece of paper. Okay? So, if you are a person with first-hand knowledge, then you skip over, you still would have to do the complaint, but you would also be the person who signed the statement of probable cause, because you are the fact witness in this case. You know for a fact this is true.
So then in this case, the police officer is acting as the fact witness.
After he's done his investigation, he could, yes.
But what
because
investigation?
Then he would have been the one that, well, again, his investigation was the traffic stop, such as it was.
Such as it was, yes.
Okay? So, the point being that that's the process for a complaint, and then you have the process for the sworn statement, i.e. the statement of probable cause. Okay? The statement of probable cause is then used as the basis for a warrant. The warrant is then issued by a judge who signed an order creating the warrant. The warrant is then executed, which means the person named in the warrant is arrested.
So, like, for example, okay, even though the initial traffic stop was for, let's say, the lamp, okay, but there was a warrant already filed prior to that, like 7 years prior, and The accused had no knowledge of it. Okay, so something like that then gave him probable cause, correct?
It didn't. It gave him, the warrant gave him the authority to make the arrest.
Uh-huh.
Okay, even if he was wrong about the headlight situation and couldn't arrest for that, the outstanding warrant was arrestable.
Okay.
Okay. The issue then becomes the fruit of the poison tree doctrine, and the fact that he wouldn't have known there was a warrant and arrested you if he hadn't made an illegal stop.
Right.
Okay. And therein lies the basis of the problem.
And that's what I even set out in my argument, that the stop itself was not, in my words, legal, of course, but I didn't say it that particular way, but that's what I portrayed.
Well, the argument should be that the officer cannot reasonably make an argument of mistake of law. Okay? The officer cannot reasonably argue that his initial stop was a mistake of law, because he should have known that the law did not require what he had stopped you for, and therefore did not give him any reasonable suspicion or probable cause to make a seizure. You get it?
Did you stop working on
Yes.
the framework or not?
The framework of what?
The cross-examination about the training.
I haven't stopped working on them, but I haven't had a whole lot of time to keep working on them. I've been trying to get ready for tonight's class. There's a specific provision for it in Chapter 30 of the Government Code. Chapter 30 at the very beginning has several general rules that apply to municipal courts of record. One of those rules is that certain ones of those courts can hear writs of mandamus. The problem is that is in direct conflict with other parts of the law that says they can't.
Oh, that's what's gotten me so confused. So what did we finally figure out? Did she put it in the right court or not? Was this supposed to go in the district court?
According to Chapter 30, yes. According to other chapters of the Code of Criminal Procedure, no.
And she didn't rule on it like she should have ruled on it if she didn't have power to hear it. She
That ain't
also
the case.
has done some stuff where she, since the case was, it used to show up on there exactly what happened in that court. But now, if you go and look at it, she changed the name to a writ of habeas corpus, and she deleted the files where you can't see the actual documents. Maybe the District Court of Appeals maybe said something to her or whatever. I don't know, because I doubt it. I don't know. I just think that she's up to no good. That's why I was telling her. But I know that she ruled on it like she had the authority to rule on it, instead of denying it, not having it. Yeah, now she's trying to act like she didn't. She's trying to act like it's a writ of habeas corpus. I didn't file a writ of habeas corpus. That's crazy. But at the bottom of it in the notes, it says writ of mandamus denied. That's the only information. If you try to copy and do a screenshot, or no, not a screenshot, but copy and paste the information off of the website that shows where the records are, it's you can't. It doesn't copy her information, or doesn't copy her name or anything, or what the notes or anything. But you can screenshot it. 'Cause I sent it to Eddie. It's weird.
Y'all give me just a second. I'm trying to see if I can find the old text file I used to use for this.
The one I did for the district court was a whole lot better than the one I did for her. But they still denied it, but still, they should have denied it because I didn't have the certified documents or anything to go along with it.
Been so damn long since I've used it, I can't even remember what the hell the name of the file
Are you
is.
talking about that chronological sheet?
Yeah, that's it. Chronology.
Is it chronological? Oh yeah, the other thing is she corrupted the link to the document, and so if you didn't know the case number, you wouldn't ever find it, because you can't copy the link that goes to it because it's corrupted. It doesn't go to it. No, I haven't pointed it out because I'll be there again on this other one.
Okay.
I'm not going to file a writ of mandamus Uh, with her, it'll just be the appeal, the regular appeal.
Did I give you a chronology worksheet,
Yeah.
Jane?
Let me see if I yeah, I actually did another one because there wasn't enough room in that one to put all everything I needed to put on the notes. Hush, I'm looking for it. Hang on.
The home rule authority is when it's a home rule charter city. That's what it's based on. They have to be a home rule charter.
And it's a self-government. Full self-government is what it says.
Self-governing.
Governing now.
Okay.
All right. This is a document I made up when I first started learning all of this, and I used it for every court appearance. And basically, we put everything up here as far as what the actual court appearance was for, when it started, date and time.
Oh, that's not the one. Okay.
You know, and I also used it when I went to view other people's cases. That's why this has the contact information and everything of someone else or someone. It's so that if I took this to use in someone else's case or was watching them fight their own case and I thought they might need some help, I could give them this and say, look, if you'll just give me your information on this, then I'll get in touch with you and we can set up a time to go over how this works and I'll help you where I can. But basically, you keep track of everything as a written record. Every time you go to court, you made one of these sheets. And the whole purpose of it was to keep you on track with everything. Okay? Which included, you know, not only the event itself, but any paperwork, things of that nature, any people that you talk to, anybody and everybody. Okay? This is how we documented everything. All right? And it was just rinse and repeat after that first page. And that's really all it was. It was just a way for you to keep track of everything. Now, you could do this in an Excel spreadsheet, but the problem is I made this so that you could print out copies and take with you and fill them out by hand when you were there. Then you can come back in and put them in your spreadsheet later if that's what you wanted to do. But I made this so that people could print them out and be able to take them to court and fill them out as needed. It was very useful at the time. But
Here, I think I found it.
But when it came to being a point where you could now audio and video record everything with your phone, this became more or less obsolete, so I haven't had to use it in a long time. But it is the reason why I've told everybody, always record your interactions with public servants. Always. Doesn't matter who they are. The only time you can't literally do that is when you're in a courtroom with a judge that isn't giving you permission to do it. Now, if you get them to give you permission, more power to you. But the fact is, that's going to be a few and far between event. If it ever happens at all. Okay.
Yeah, I can't find it.
All right, so. All right, well, once more then, let's go back over some simple basics here about cross-examination. Everybody pay attention. This is important to know. And it is part of what you need to study, okay? But y'all really, really need to take the time to sit down and read, at the very least, the criminal complaint, all three of them, each thing filed by the prosecuting attorney and each thing filed in response to what the prosecuting attorney filed. Okay? Because you will see exactly the kind of BS they try to pull and exactly how you need to address it. And what makes it more of a challenge is you've got to learn to think about things the way that I wrote about them in your head on the fly in real time. Because when you're in court, you don't have the ability to sit down and read and analyze before dissecting something and responding to it. You've got to be able to do it right on the heels of it being said or done right then and there. And that's what separates in the legal world, that's what separates a trial lawyer from a pleadings lawyer. Okay, most big law firms have a set of lawyers that do certain jobs. There are research attorneys, there are attorneys that write the pleadings, there are attorneys that actually go to court. They are not always the same attorney. Okay? And the reason for that is you have some that can't think on their feet well enough to argue in a courtroom in a live session. They don't know the law well enough. They don't know the subject well enough. They don't know the procedure well enough. They don't know how to be articulate. They don't know how to make a point. You know, choose your poison. The fact is they're not really fit to be a trial lawyer. But you don't have the luxury of failing in that if you're going to do this for yourself. You've got to become the best you can be at all of these jobs. Okay? An example being, somebody sent me a document they filed. And right off the bat, I knew this person was a danger to themselves beyond even their ability to discern. Because every single case they cited is a case that's already been overturned by the courts in lieu of something else. In other words, they didn't shepardize their case sites. They just put in something they read that sounded good without understanding what it was and whether or not it was still any good at all. That's a mistake. A big mistake. It's as big a mistake as the bullshit arguments the city attorney was making in Jane's case. And trust me when I tell you, every argument she made was a completely bullshit argument. Every single one of them. And in my response, I treated it exactly like what it was, a bullshit argument. And I called her out on every single one of them that she made. Did I or did I not, Jane?
Yeah, you did.
Okay.
Doesn't seem like that they can win. I mean, it doesn't seem like they could convict me.
At this point, Jane, there is only one way they can win, and that's if they scare you into giving up like they did the first time.
No, I'm not. They're not going to.
Well, but at the same time, what else can you not do?
Can I not do?
Yeah.
I have to do the appeal right.
But what, during the process of getting to the appeal, do you have to make sure you do not do?
There's lots of things, but
Then give me some of them.
Well, do not miss the appeal date when I'm supposed to file.
Well,
and,
that's one thing, not the things I'm looking for, but go ahead.
Well, give me a hint.
What do you seem to have a real problem with when it comes to going to court?
Lose my temper.
There you go. First and foremost, don't lose your temper. Maintain your self-control. Think before you speak. And I don't mean try to think quickly. I mean really think before you speak. Okay? Part of that thinking before you speaking is listening very carefully to what the other side is or has been saying, so that you have something to actually think about and respond to. Correct?
Mm-hmm.
Pay attention. Don't fly off the handle. Don't get misdirected either by the prosecution or by your own lack of understanding. Focus. Know the points you have to deal with and deal only with them. Don't go chasing your tail or running off down side trails that aren't going to lead you back to the main path. And trust me when I tell you, there are very few side paths that will ever do that. So what is the best plan when it comes to side paths in a trial?
Stay off of them.
There you go. Do not let someone lead you into taking a side path that doesn't matter to the facts of your case. Okay?
Okay. But how do you ask questions about what considers to be, I mean, not what is.
Okay, there's one thing about the questions I have given you in this script so far. Every single one of them is on point with the specific things you have to ask. Now, you can come up with any other questions you think will help, but they have to be focused on that set of things. And only those things. You understand?
Okay. What would be my exculpatory facts and evidence?
The fact that they can't prove any of the elements of theirs.
Okay.
They have absolutely no supporting evidence of any kind for anything they've alleged in that complaint, do they? Not
No.
one single element.
No.
And let's go over that real quick. There is no offense relating to simply feeding an animal, whether it's indoors or out, right?
Right.
So the feeding of an animal only becomes an element, according to the ordinance, if what happened?
If one of those things happen. One of the three elements.
If the feeding itself created one of those things.
Yes.
That constitutes the actual offense.
Yes.
Right?
Yes.
So just saying you fed an animal outside is not an element of the offense.
Right.
There has to be more. The feeding must have resulted in one of those things listed in the complaint.
Right.
Do they have any evidence of any of those three things listed in the complaint? Any of them?
No.
There you go.
But
That is all you have to worry about.
right.
That is it. Every single question you ask needs to be organized in the ones I've already set up to focus only on that. Don't ask the same question a different way multiple times. Figure out if I've already given you the question, and see if you can build on it without repeating it to get something new and relevant if it's even needed.
So
Don't beat a dead horse. Okay? Don't drag shit out. If you have proven the element doesn't exist, move on.
So since they can't define, and since there is open to interpretation.
Wait.
Oh.
Defining things is not the point here, Jane. The
So it's
simple
not
fact,
important.
the simple fact that if they make the argument that it constituted this, then please provide the specific definition of what this is. Because right now, that's simply your opinion, and that opinion is 100% subjective. It's not a fact, it's your opinion.
Right.
Because it simply didn't happen. So either show me a definition defining what it is, and then prove that thing existed, or you don't have a leg to stand on. That's the only time you ask about definitions, Jane.
Okay.
Now, it's okay to put questions in there to be prepared for it if and when it happens. But that is a slightly off the main trail. It's not a complete side trail, but it takes you off the main enough that you got to veer out, cover it, and come back. You follow?
Yes.
It's an alternate path back to the same trail, but it's still not the main trail. Unlike a side path that you don't know where the fuck it's going to end up when you take it. There is your distinction. So alternate route versus side trail. Alternate routes have their uses if and when they're needed, but not always. But anything they try to say about this, or this, it's all their opinion, Jane, and they cannot testify to their opinion. None of them are expert witnesses. None of them are going to be sworn in as expert witnesses. Okay?
Yeah.
And that's exactly what we ask them. The very first thing. You were not sworn in as an expert witness on this subject, were you? No. Great. Then I will do my very best not to ask for your opinion like the prosecutor kept doing.
Oh, you were saying that I should be able to access the docket or whatever online. They used to have the docket online. It used to be public information, but now they don't publish it anymore. Since I've been, because I went to some of the hearings that was published on there to try to see how they treated other people, and they were like surprised. I mean, they were real standoffish about letting me come in there and sit down and listen to somebody else's hearing. But all it is the prosecutors.
They don't have a choice. It's a fucking public. All courts in Texas are public. They don't have a choice.
I know, but now they don't publish those when the trials are, who's going to be there, or anything like that.
Then I'd file a complaint with the city manager about it. That the courts are intentionally hiding their schedule to suppress public participation in the courts.
You see Kristen Wade's site. She doesn't have anything. She doesn't have her rules. She doesn't have anything on her site for that court. Her docket is 0. She has nothing in her docket or anything.
Well, again, that just proves she's not a very good administrator.
Probably doesn't have any cases.
That may be true too. But why is she relevant to you then?
Because that's the one I have to appeal to, unfortunately.
Well, again, you stand on the record made at trial and your pleadings. That's it. Because this is a court of record, so it's not a de novo. They have to base it on the record from the court of record.
Right.
So focus on what you have to know and understand. Don't lose your tempo and your self-control. Stay on point. Don't leave the main road unless you have to, but make damn sure you always come back to it at the point you left off, unless going around something is beneficial, and it very rarely will be. Okay? And just deal with it.
Yeah, I'll have to come up with I already come up with like 4 or 5 objections, but I don't know if they were Eddie approved.
What are you calling an objection? An objection to what?
I mean, for like when we have a trial, let me see what I call them. Trial objections that it needs to be filed whenever they.
The objections need to be based on things you can make legal objections about.
Right. Like.
Okay? In other words, the objections don't change just because of the court you're in. The objections are almost always universally the same. Objection, hearsay, objection, relevance, objection, argumentative, objection, legal conclusion.
Oh, I mean written objections, like objection.
I understand, Jane, but the written objection still has to be based on one of those. You get my point?
Yeah.
There has to be a proper legal basis for what you're objecting to. Doesn't matter if you're doing it in writing or verbal, it still has to have a legal basis for making it.
Objection to discovery violation, objection to...
Yes, exactly.
Objection to the court for denial of motion to quash.
But instead of making that a written objection, I would make it a motion for sanctions.
All right. I can't change the venue without getting 2 witnesses. Or 2 people, credible people to be a witness.
I know, Jane. Donna, there's a little bitty handbook called Meeting and Making Objections. You can get it on Amazon. Barnes and Noble, I think, has it, but it's called Meeting and Making Objections. And I believe it was a federal judge that put it together. And basically, it's a little tabbed book that's, okay, say I want to make this objection, so you pull it open with that tab, and here is the objection, the way you make it, and here's the reasons why you can make it. It's a very useful little handbook. I still got a few of them around here somewhere, but God knows where. Most of my stuff's still packed in boxes.
And also raising exceptions.
No, exceptions are different than objections. And you don't, nowadays an exception is considered inherent.
Who wrote that book on meeting and making objections?
I think it was a federal judge, but I don't remember his name. But just do a search. It's a little pocket guide. It's a little tabbed pocket guide.
$300.
No, well, where are you looking? Because it's only
On
$25.
It's $299.99. But
Yeah.
and then you can buy it. Well, that's buying it used. So maybe we can find it somewhere else.
One left in stock.
I still think you can find it somewhere else.
There's a question. Do they even have anything, Eddie, that you used in order to do cross-examination?
What do you mean?
Well, any guides or guidances that you use to help you like create your questions for cross?
I read everything I could find. I read court opinions. I read transcripts. I read law books. I read legal writing books. I spent a shit ton of money. I mean, hell.
Here's one that's a pocket guide to common trial objections for federal and evidentiary foundations. $11.
This is just some of the books, okay? I've got all kinds of books down here. And I used to have a big old set of book racks. I got an entire law library from a law firm that was updating their books once when I was in Austin. And when I say an entire law library, that's exactly what I mean. Y'all's been in lawyers' offices where their entire wall in their office is covered from floor to ceiling with books? That's what I got. I had an entire collection of that. And then my friend Dan put them in his storage unit while I was moving, and then didn't pay his storage, and I lost them all. But, I mean, and no, you get most of these law books are not cheap. Now, there is a place in Texas, the County and District Attorneys Association, that puts out books.
That little book doesn't look like it's tabbed, but it might be on one. It's Robert Winkie.
Now, there's the link to the Texas District and County Attorneys Association books page. You can actually order books directly from them, and they're way, way cheaper than you would get them in a lot of other places. They're not cheap, but they're still hundreds of dollars cheaper in most cases than they are anywhere else.
Texas have a law library in their
They have a state law library in Austin. Most Texas universities also have a law library.
So I don't know if maybe that might help you guys out. Then now in Indiana, we have a LexisNexis availability online. A law library.
If you have an actual law library, the state law library has that as well. They've got several computers with both Lexis and Westlaw on it.
Well, in this one, I'm noticing on this Texas district attorney thing that you just sent, they've got one for Texas traffic code and traffic law.
Yeah, they do.
The court's not going to let you use that when you're in court, though, are they?
Yeah, they are. They're an official publication.
Law library, man. I mean, actually, you can make up our own little book for tab book for objection.
Well, if anybody has access to Scribd, there's a link where you can download a scanned PDF copy of
Okay.
that book.
Really?
What was the judge's name on that book?
Winky, W-E-N.
Yeah, Robert Winky, I believe it is.
Yeah, Judge Robert Winky.
Spell his last name again. W-E-N-K-E. All right, Jane, you see these sections here where I don't have any specific questions yet?
Yeah, hang on. I gotta close this out. Yeah.
Okay. Those are the parts you can work on, but they need to, each question you put in that section needs to focus on the title. Okay? Whatever question you ask needs to build one upon the other. Okay? Just like a set of stairs. Start at the bottom, the simplest question that naturally leads into the next question. But the question needs to be relevant and it needs to stick strictly to what we're asking about in that specific title section. Okay?
Okay.
All right.
What?
All right. In the meantime, there's a study sheet that you guys can use for objections. Can everybody see it?
Mm-hmm.
All right, real quick. Feeding, manner of. Everybody remembers what the ordinance that we looked at said, right?
Mm-hmm.
So, what kind of questions should we ask about the manner of feeding?
I'm waiting for somebody else to answer since I'm. Anybody else want to answer?
Nobody else has done the reading, so they haven't looked at the ordinance. They don't know.
Okay.
The only people that's going to know anything about the ordinance are the ones that have been in the regular class up till now.
So what? Well, we have to establish that the manner of feeding is different from the danger.
Is a
No,
public
we don't
threat.
have to establish that. That will be self-established once we break it into these pieces. So, what's the first question we need to ask about this section? Now, that's assuming, of course, we didn't ask that same question up here.
I don't have this, so.
Why don't you have this? I put it in the drop. I put it in the links last week. I thought.
You said you weren't finished with it.
Okay. Here's what I would ask. That's where I would start. Officer Delgado, you heard the reading of the complaint, correct? Now, you can also build a little more foundation if you want.
I'm not gonna let me let him read.
That complaint is based upon a citation that was issued by you, correct?
We need to build up to that fourth question. No, that fifth question.
We built that up here, Jane. Everything up here was asking them about the ordinance.
I know.
Okay?
But assuming they don't let me give the ordinance. Which,
You can still ask the court to take judicial notice of it, and you can still ask the court to allow the witness to look at it to answer the question. But you did not personally witness anything at all regarding what you wrote. See, that affidavit that Smith signed does not have a penalty of perjury statement on it, does it?
No, it doesn't.
It's Jody Smith, right?
Joni.
Joni. N.I.
Yes. It's a dangerous animal affidavit. You're gonna go outside. Come on.
Okay, Officer Delgado, you heard the reading of the complaint, correct? That complaint is based upon a citation that was issued by you, correct? But you did not personally witness anything at all regarding what you wrote in that citation, correct? You based the issuance of the citation entirely on the hearsay of one Joni Smith, correct? You heard that one of the allegations in the complaint is related to the feeding of animals, correct? Can you please read the portion of the ordinance that says feeding animals in and of itself constitutes a violation of the ordinance? And you keep building on it from there. Okay? Same thing with the danger to public health. Except now you get to start with number 5 in this one and this one. Okay, because we already know about the complaint, we already know about the citation, we already know they didn't personally witness any of the facts that they're up here testifying to, and that they based the issuance of the citation entirely on the hearsay of one Joni Smith. Now, that Ring camera video, does it have a date and time stamp on it? Jane? If you're talking, which it looks like you are, there ain't no sound coming out. There you go. Get closer and say it again. Class to Jane.
Yes, I'm here. What'd you say? I'm sorry. I had to.
I said that after you get done with the manner of feeding questions, you get to start every other section at question 5, because you've already got the facts from 1 through 4 of the feeding. Okay?
All right.
Now, the Ring camera video supplied by your neighbor, does it have a date and time stamp on it?
Yes.
You can see the date and time stamp.
Yes.
Great. Then another question is, they're going to try to say that, well, I saw it in a video. Okay.
You know what though?
Were you personally present at the time the video was taken so as to observe those events yourself, or events personally?
You know what? It's embedded. It's written in the video itself, which is something strange to me because usually it's the name of the file. It's not like written into the video like somebody added it there.
Okay. Does the Ring camera video have an embedded date and time?
Yes, it does, but it looks like it's been added to the video.
It would have been added to the video by the Ring service when it was being streamed to Ring. That's what a Ring camera does. It doesn't store it locally. It stores it on a cloud server.
But I need to look see if that, because I thought she had Arlo cameras, and I don't think that she has a Ring camera that could have taken that. Because I can see her cameras clearly.
If they have any kind of security system, it will almost always put a date and time on the video when it makes it.
Okay, like on the ones that I have for Blink, the name of the file itself has
We don't
the.
care what the name of the file is, Jane. The name of the file is not at issue here.
I mean,
I
okay,
don't care if they called it shit I saw yesterday.
the date. I'm saying that the date is in.
Doesn't matter if the date is in the name of the file or not. All that matters is, does the video show a date and time when you play it? Okay, that's the only question I asked. I didn't ask a damn thing about the file name. There's another one of those side trails you need to fucking avoid. You got it?
I got it, but you're missing my point.
No, there is no fucking but. Do you got it?
Yes.
Okay then. Now, do we need to ask this question? That's a question for you, Jane. Do we need to ask this question?
When the present. No.
Why?
How could she have been there to?
It's not a question of how could she have been. The question is do we need to ask this question and why?
Okay. That if she didn't observe them personally, then why is she issuing a citation? Because I thought you'd said that the law said that they had to witness it in person.
Correct. That is why we have to ask the question. It's not you have to remember that officers don't have to be present to use video as evidence of a crime. Okay? The officer doesn't have to witness anything. The video witnessed it, and that's the evidence that the officer is collecting and submitting to prove the case. Right?
Mm-hmm.
Okay. However, this is not simply about submitting the video as evidence. This is about the officer issuing a citation based upon a video rather than something they saw themselves. And Texas law does not allow them to issue citations unless the offense is committed in their presence or view.
Where do you see that?
It's in every place where they're authorized to make an arrest without warrant, Jane. Chapter 14 of the Code of Criminal Procedure says it. Chapter 15 of the chapter 543 of the Transportation Code says it. A peace officer may arrest without warrant any person found committing a violation of this subtitle. Chapter 14, an officer may arrest for any offense committed in their presence or view. Okay? Or they can issue a citation for an offense committed in their presence or their view. But they can't just come by and issue a citation because of something someone else said or showed them.
They convicted me on that before, but anyway.
Conviction's not the same thing as issuing a citation, Jane. Those are completely separate acts.
Right. And the officer that got me for the theft and the trespass for my cat, that one was issued by mail after viewing the video, not seeing anything in person.
They issued a citation for that?
Yeah, for rescuing my cat. Yeah, the officer came over that night. He didn't give me a citation. It was the investigator 5 months later who sent them to me in the mail. For theft and trespass for the night that the other guy didn't issue a citation.
I'm sorry, baby. Didn't mean to kick you. Okay? The point being is you need to understand whether or not you need to ask the question. Okay?
Okay.
Does this question help us prove the point about whether or not feeding is an offense?
It does not prove that point.
Okay. Does it prove any of the other points?
Well, it proves disproves all the points.
It doesn't disprove anything, but it doesn't prove anything either.
Okay. So when you take it out?
There you go. Despite the fact they can't normally issue citations without them, it being done in their presence or view, that question doesn't help us prove anything, and it doesn't build us up to anything to prove. So, treat it like what?
It doesn't matter. Irrelevant.
Which would make it a what in relation to our main path?
Irrelevant.
Yes, it's irrelevant, but it's also a side trail that we don't need to follow.
Well,
Okay.
I'm sorry, but I'm stuck on one right this minute that's in my mind. I'm sorry.
Which is what?
Which is, now that I mean, I already know that the camera system that she has outside is not a Ring camera
It
system.
doesn't have to be a Ring camera, Jane. It doesn't matter what kind of camera it is. All that matters is, does the system automatically put the date and time on it? If it does, that's all that matters. The only reason that would be a problem is if she manually adds the date and time after the fact.
That's what I'm saying.
Well, do you have any reason to believe she does, or can you prove that she does?
Well, you're saying it doesn't matter. It's a Ring camera, but if it's a Arlo camera system, then it can't generate that. It says Ring camera in the embedded, like you're talking about, in the video itself, and also says the date and time in there. And it's impossible for her Ring camera to have made that video, because I know the angle of where that camera's at, and the only one that did it was the Arlo camera.
Well,
And it
again,
wouldn't-
how do you know the Arlo camera system can't do that? The camera may not be able to do it, but the system it's attached to can, that's doing the recording.
Because all the cameras have their own system, their own cloud, everything. Just like Blink has its own stuff, Arlo has its own stuff, Ring has its
No,
own stuff.
they will all be attached to the same account, Jane. It
Oh,
would
I'm
be
not-
pointless to have a separate account for every camera. They would all go to the same account. And if they go to the same cloud server, then because they're security video, the cloud server will be the one that puts the date and time of the stream on there.
Okay, how many camera systems do you have?
I've installed a lot.
Well,
I did that all the time when I did networks for people.
Does anybody else understand? Does anybody else see what I'm saying? Like, Blink has their own servers, and they're not gonna. You can't use Blink and Arlo's server together. They're not on the same server. They have their own.
The
security
question is
system.
not whether or not they can use the same server, Jane. The question is the camera capable of being attached to either service? If the camera is just a camera, it doesn't matter what fucking service it's attached to, regardless of the brand. The only time that would make a difference is if the camera is hardwired to the service like a Ring camera is. Otherwise, the camera is just an eye that any brain can use to see through. The brain being the server.
It's not that though.
How do you know that, Jane? Are you an expert on these camera systems?
Hang on a second. Yeah, but I've looked it up. I saw that that's the Arlo system, and she only has a Ring camera on her front door. That's it.
No, Jane. You've seen that it's an Arlo camera. You do not know what system it's attached to. You're assuming, but you haven't been in her house to see, have you?
No, but you can't attach. It's not cross-platform like that. I mean, like, I can't get an Arlo camera myself. And
Spell
attach
the
it to
name
my
of the
Blink.
camera, Jane.
Huh?
Spell the name of the camera.
ARLO. And I got both of those cameras have what do you call it? Solar panels on them.
You sure it's not ARLO?
ARLO, that's what I said.
These are home network attachable,
Yeah, I know. Mine are too.
which means you can attach them to any recording system you have.
No. Oh, no, you mean record? You don't have to have a recording system. They're the cloud. They're on the cloud.
They can be, Jane. They don't have to be. They are network attachable. They can be used to record to your own home security system. It says it right in the description of the camera.
Just for instance, I can't buy an Arlo camera or a Ring camera and hook it up to my Blink system.
Again, Jane.
They have different I don't know what you call it, MAC addresses, and that communicate with their devices. Because I've had several different kinds of cameras.
Again, Jane, you're talking apples and fucking oranges.
Okay.
A home system recorder is not a cloud service.
She doesn't have a home freaking recorder. She's got a Blink. She's got like a regular network camera, like I do, like everybody else.
How many times
does.
you been in this woman's house?
I haven't been, but
Then you don't fucking know that. So stop arguing about it.
Nobody.
You're assuming shit again.
Nobody needs that shit anymore.
Needing and having, Jane, two very different things. I, for one, would not want my home surveillance on a fucking cloud camera if I could protect it better, or I was using it for things other than just my home security.
Not that smart.
Are you assuming she can't pay someone who is, Jane, to install it and set it up for her?
I just anyway.
You just.
Move on. I'll just have to deal with it. I'll have to figure it out.
Again, you're chasing side trails. Stop it. Okay. You heard one of the allegations of the complaint is related to the feeding of animals. Can you please read the portion of the ordinance that says feeding animals in and of itself constitutes a violation of the ordinance? Okay?
Hey,
Build
Donna.
on that. Okay. So, then you do the same thing with the danger to public health, same thing, the danger to public safety, all of it.
Okay.
So, since I can't get anybody to do the damn reading, let's see if we can get anybody to do some damn writing. I'm going to give you guys this outline for the cross-examination questions.
Can we go over something like Donna's questions or something? Other people got questions.
No, I'm not going over anything different. I just want everybody to have a copy of this. Y'all hang on a second. Somebody has got to be at my door for these dogs to be acting this way. All right. Now, in the material I gave you guys to do the reading on, if you will look in the zipped files, there is a copy at the very bottom, DEX D01, City of Irving, Texas Ordinance 680, Animal Nuisances and Permits. That is the specific ordinance that we're dealing with. Okay? That is where the sections of this cross-examination script are taken from. Okay? So, what you're going to do is going through that ordinance, you're going to look at each of those individual subsections that constitute the actual offense. And you're going to organize, or you're going to outline your questions and stair-step your questions according to what specific thing that has to prove. Now, I gave all of y'all a sheet on how to break it down, right?
Yeah. Well, no. This specific one?
That
No.
ordinance.
Oh, yeah.
Anybody remember what the name of that file was? Was it in this one or was it somewhere else?
Uh,
I think it was downloaded in the chat.
Yeah, I'm trying to remember if I gave it in a written format or if I did it in some other way. There we go. Yeah, general framework of ordinance or statute. And then how to break it down. So, you can use that worksheet to outline the questions that you need in each one of those sections. Everybody understand how to use it? So that Word document that Julie just uploaded, everybody download that if you haven't, so that you have it. And just real quick, I'll explain to you how it works. Can everybody see the color-coded document on the screen?
Yeah.
Okay. Everything that's in yellow is the very top is the general framework of the ordinance, and then the general statement beginning the offense. And that corresponds to these three things. Okay? Or I'm sorry, that corresponds. This up here corresponds to this right here. Okay? Then the sub items that are underneath this right here in the ordinance, such as this one, corresponds specifically to these things in green. Okay? And this one right here corresponds to these things in yellow. This one here in blue corresponds to these things in blue. All we did was break down each one of these three things right here into its component parts over here. Okay? And it teaches you how to better understand a statute by breaking it down that way. Let me go through this real quick and I'll show you. General framework of the ordinance. The owner of any animal in the city is responsible for the behavior and conduct of that animal at all times, including conduct that creates a public nuisance. A person commits an offense if by act, omission, or possession he or she allows an animal to create a public nuisance. The following are public nuisances. So our takeaway from this as far as who can commit the offense is the owner of an animal and the owner having responsibility for that animal. Okay? Specific subsection of the ordinance or statute that lays out the offense. A person commits an offense if he or she intentionally feeds any animal or makes food available for animal consumption in a manner that means it must have resulted in one of these three things. Okay? So, if we break down this and these three things, we get these things. Okay? Which are the individual pieces of those things. So, a person commits an offense if the person does any of the following: intentionally feeds any animal or makes food available for animal consumption, and that is done, either of those are done in a manner that. Everybody understand? These are an either or thing. It's not both together, it's either or. If either one of these is true when paired with this, and it resulted in one of these things, then the information in yellow will be true. Okay? However, at least one of these three things must then be true in addition to what's in yellow being true. So, the feeding or the animal consumption of the food was done in a manner that creates a danger to the public health or creates a danger to public safety. Because remember, it says creates a danger to public health or safety. So, we break it down. It creates a danger to either the public health or it creates a danger to the public safety. Well, what are the facts and evidence supporting that one of those two conditions is true? We want to ask questions that show there is no facts and evidence that make any of those conditions true. Okay, so then we move to the second one. Destroys public or private property. Once again, an either-or situation, because there's or right between them. So, destroys public property or destroys private property. What are the facts and evidence supporting the destruction of public property? What public property was destroyed? How was it destroyed? Okay? So, not only was it destroyed, but how was it destroyed? Because the destruction must have been caused by the animals. Okay? If it was destroyed in any manner other than by the animals that were being fed, then the destruction is irrelevant. And that's true whether it was public or private property. For instance, if you're feeding animals outdoor and the only animals eating at your food are cats, and some raccoon comes along and tears up public or private property but never goes anywhere near your food, then your food was not the reason that raccoon showed up. And there's no evidence that your food is the reason that raccoon showed up, because the raccoon never went anywhere near the food. And it doesn't matter that the raccoon destroyed public or private property, because there's nothing that ties the raccoon to your feeding. See how that works? The feeding, there's no way to prove the feeding in and of itself caused the raccoon to show up, or caused the raccoon to destroy public or private property. Right? No evidence of it. All they've got is, well, the raccoon wouldn't have come there. Oh, really? You're able to communicate with raccoons and the raccoon personally told you the reason they showed up and it was because of the food? Or are you just making an assumption, despite the lack of evidence, on any video, photographs, or anything else that shows the raccoon eating the food? What are you basing your presumption on? Because it's certainly not fact, and it's certainly not first-hand knowledge of that fact. So where are you getting it? Well, I can tell you where you got it. You just made it up out of thin air. It's your opinion, not a fact. Get how that all has to tie together for it to work?
Mm-hmm.
All right, so now if we go back up here and we look at this and how it resulted in number 3, causes more than 10 adult animals to congregate in one location at the same time. All right, so it must do that more than 10, okay, more than 10 animals. They must be adult animals. Okay, so it has to cause and more than 10 animals, and they must be adult animals, and they must congregate the animals must all congregate in one location, and they must congregate Okay? The animals must all congregate in one location, and the animals must congregate in that location all at the same time. And actually, we can. So, each one just builds upon the next. So, they must be adult animals, and the adult animals must all congregate in one location. So, you can see you've broken it down correctly if the last one winds up right back where they were. Okay? So, everybody get how that would all play out?
Yeah.
So, if you read something like that, a statute, an ordinance, or whatever, break it down this way, and it'll become clear to you what they have to prove. They have to prove each one of these things down here. Okay? In order for anything in gray to be true, they have to prove all 5 of these points. If they miss even one of them, the charge fails. You get it?
Doesn't prove any one of them.
Well, you can't prove any part of the allegation if any part of it is missing.
Right.
Okay? Same thing here. They have to prove all 4 of these. Either it destroyed public property or it destroys private property. And same thing here. There are 9 things they have to prove in this one. The danger was created. There was an actual danger. The danger was to public health. Or you created a danger. The danger did exist. And the danger was to the public safety. Okay? I'm sorry, 6 things. So, they either have to prove these 3 all happened, or they have to prove these 3 all happened. Same thing here. They have to prove these 2 both happened, or they have to prove these 2 both happened. Whereas on this one, they got to prove all of that. Okay? Then to even get to any of these individual offenses, where the actual offenses themselves are, they have to prove these 3 things. Okay? And you could actually break this one okay, intentionally and feeds any animal, or makes food available and for animal consumption. You could break it down that way too. Don't have to. But you
Are
could.
these the statutes that she's charged under? I'm sorry.
I'm sorry, you're really warbling and garbly. Can you move a little closer or speak a little clearer or louder or
Is
something?
that better?
Now you're vibrating a lot.
No idea what's going on.
Okay, that no idea that part was clear. So whatever you did when you were saying those words, do that again.
All right. Is that better?
Yes.
Okay. I'm sorry if you've already explained. Are these the statutes that she is being charged under?
This is the ordinance. This is a breakdown of the ordinance she's being charged under.
Is it just the one, or is it multiple?
It's the one that I gave y'all in the packet, but let me give it to you again.
I apologize.
That's okay. All right. In the chat, once again, are the two documents dealing with the city ordinance. The first one is the ordinance itself. The second one is the definition section relating to that ordinance. So the first one, the one that says DEXD02, that's the one that's got the ordinance that we're breaking down right here. So when you're doing it and you're making your questions, that's what these individual sections down here deal with. Each one of those color-coded sections in that breakdown document. Now, Jane, do you want to try working up some questions that follow this outline?
Right now, or
No, through the week.
yeah. I will.
Okay. That's the homework for you guys.
Eddie, I can't wait to apply this. Thank you so much.
No problem. If you can learn to break down a statute that way, then you can learn exactly what they have to prove. Not only do they have to prove it, but they have to allege it in the charging instrument. Okay? Now, the problem is, all this city attorney did was make a copy, basically, a verbatim copy of the ordinance and stick it in the complaint. What she didn't do was put any details in there that ties the elements of those offense to Jane's actions. They just simply say Jane fed an animal. After that, it's all ordinance. There are no other facts relating to what Jane did and how it caused a public danger or a public safety concern or damaged property or caused 11 or more animals to congregate in one place that were all adult. Okay? There's no facts for any of those three things. The only fact is Jane fed an animal. That's it.
Didn't say where.
Didn't say how. Didn't say how it created any of the things that followed. In fact, the way the ordinance is written, she could have fed them in the floor in her kitchen and still been just as guilty according to the wording of the ordinance.
I think this is the first time they've ever actually prosecuted this type of case.
I'm sure it's the first time I've ever prosecuted one where anybody fought back this way.
Probably.
Oh, I just went for this similarly here up in Indiana, where they couldn't even state the fact on the charging instrument to me as well. I think exactly how it's feeling.
Well, you're still breaking up really bad, Rebecca. You're hard to understand.
Sorry.
That's okay. I don't know what are you on, a phone?
Yeah, I had to step away from my laptop.
Okay.
But I said I just went through this pretty much almost exactly same similar charge, like with what I was dealing with. The officer didn't name any of the elements of the charge that I was charged with, and the prosecutor just went with it. It was all conclusory statement.
Now, you say he didn't cite any of the elements, or he didn't cite any facts relating to those elements?
Either or.
Well, they couldn't have put in a blank complaint and prosecuted that. They had to make some kind of allegation.
Yeah.
The question is did they put in everything they were required to put in?
Well, in the charging instrument, they just basically did what they're doing with Jane, copied and pasted the
Statute.
definition, yeah. By saying that I made unreasonable noise and continued to do so after being asked to stop, and there was no context in it whatsoever.
And there were no facts alleged in the complaint, such as what the decibel level is of the alleged noise,
Correct,
what the legal limit is on that decibel level, how that level was determined, et cetera, et cetera.
Exactly. And the only thing the officer stated, which everything was refuted by body cam footage, he said that I was all screaming, and I wasn't. The body cam footage disputed it.
So you won, right?
Yes.
Okay.
They threw it out.
Now, did you sue for malicious prosecution?
I'm working on that right now, actually.
Okay.
Getting my pleadings all together for it.
See, that's the part this city attorney Cantu fails to realize. See, the first thing I filed in Jane's case had a section in there for malicious prosecution. We didn't make a claim for malicious prosecution like we were suing them.
Yeah.
What I did was I simply laid out the fact pattern showing how what you're doing is walking the city and yourself into a malicious prosecution lawsuit if you continue with this case. That's what I put in there.
Yeah.
She then turned around and characterized it to the court in her rebuttal response that we were making a claim for malicious prosecution and the claim wasn't timely. So I turned around and in the next response I sent back, when she changed the criminal complaint in response to our motion, after saying that the way she did it was perfectly valid under the law and there was nothing to change. But she changed it, didn't she, Jane?
Yep.
Which is a confession that you caught me, I fucked up, and now I'm going to try to fix it. But she still fixed it incorrectly when she did.
Yeah.
So we submitted another one. And I did the exact same thing again, but this time I clarified this is not a claim for malicious prosecution. It is a step-by-step guide to how you're fucking up and are going to get sued for malicious prosecution at the conclusion of this case.
Yeah, I didn't give them any explanation that I was going to be suing them for malicious prosecution.
I wouldn't either.
I just let it be a surprise to them. But
yeah, well, in this case, I had to because I don't think Jane would go the extra mile to do it. And I don't think Jane, if we could scare them off without Jane having to do any more in court, the better it is for her.
Right. Well, I had to have my last hearing. It was almost like a trial. I had to cross-examine the police officer and my husband. He was my direct witness, so I had to do all of that. But at the start of my case, they charged me under the wrong statute number, but the language in the charging instrument was completely different. And instead of, keep quiet about it like I probably should have before trial.
No. You can't do that.
Well,
don't make that mistake. If you don't challenge the charge that's in the complaint before a certain date and time in most states, then you don't get to challenge it at all.
Right. Yeah. I challenged it early on, but in Indiana, if you were to challenge it at the trial, then the state would not be able to amend that charge.
Right. But at the same time, you don't get to, here in Texas, if you don't get to challenge the complaint if you don't do it at least a day before the trial begins.
Right. Yeah, I think it's similar here in Indiana. But I mentioned it, I challenged it early on. And when I had to move my case to a higher court, the circuit court out of my local city court, they then amended the charge. But it was a disorderly conduct charge, and that's under, the public offenses chapter. So the prosecutor knew when my case, before it even started, really, before the charges were even filed on me, that the traffic stop that it stemmed from was wrong. So she knew the whole time that I was being prosecuted that the traffic stop was wrong, it was unconstitutional, and everything like that.
Yeah, and that's exactly what this woman's doing. She knows there are no facts that prove any of these elements of this ordinance true. She knows that. She has no evidence of any single thing. And yet she's pursuing the prosecution anyway. And she's attempting to mislead the court on the basis for which she's doing it.
Yeah, that's what the prosecutor tried to do with me here at my last hearing. She tried to get me to delete exculpatory evidence. And I had brought it up during the court hearing on the record that she was doing that. And when the judge finally wrote the final order, they pretty much put her in her place. They told her that they gave her every opportunity by law to affect the charge and respect what they were doing, and they still couldn't get it right.
Well, the thing about the prosecution in Jane's case is that this is being done by a city attorney. And what the city attorney does not realize is they have no qualified immunity because they're not real prosecutors. They do not have the protection of the state in the form of qualified immunity. because the Texas Constitution did not give them the power to do what they're doing. The legislature did. And the legislature violated the state constitution when they did it. Because in Texas, only the elected county or district attorney can prosecute a case in the name of the state. So there's no way for the legislature to give immunity of any kind to a city attorney when they're acting in an unconstitutional manner.
Well,
Wouldn't that still apply to like just regular county attorneys as well? I mean, I think the absolute immunity can be.
No, they only don't have absolute immunity if they committed an actual crime in the process of the prosecution. Like they falsified evidence knowingly, or they hid evidence knowingly. That's a criminal act against the accused. It's a violation of their rights.
So with the prosecutor, for example, in the case against me, where the prosecutor had attempted to get exculpatory evidence deleted, that technically...
That's tampering with evidence. That's a crime.
Okay. I filed bar grievances against her and her deputy for that, because her deputy I had to deal with from the start of my case until circuit court, and then...
Well, when you say her deputy, do you mean her investigator?
No, her deputy.
Okay, so you mean a deputy attorney?
Yes.
Okay.
Deputy prosecuting attorney. She must not have liked that he was not being successful in getting a conviction out of me, and so she ended up, the elected prosecutor took over my case, which I've never seen that happen before. It's usually the same prosecutor sees the case start to finish.
If they don't throw out, I mean, if they do dismiss my case, I'm still going to sue for malicious prosecution.
As long as it's a favorable outcome for you.
No, because they've hijacked my life for the last, since 2019.
Yeah.
I'm sick of them having control over my freedom.
Eddie, can I ask a question about this malicious / sovereign immunity, malicious prosecution / sovereign immunity, or prosecutorial immunity?
Yeah.
So I'm a little confused when it kind of kicks in. So you just said that Jane's prosecutor knows that there's nothing there, but she's still going through it. So she's already in malicious prosecution territory, yes?
Yes.
Okay. If she drops the case before it gets to trial, then that just solidifies.
Then that's in Jane's favor, and Jane can sue.
Okay.
If Jane wins, Jane can sue. If Jane gets dismissed at trial or gets a directed verdict in her favor from the court, Jane can sue. The only way Jane cannot sue at this point is if they actually win the case and Jane doesn't do or win her appeal.
Has there been a preliminary or an arraignment already?
We don't have, it's not an arraignment, but no, we're going to have that on September 16th.
You've never even been before a judge yet?
Not on this one, but I have another charge that was the same thing that...
Donna, to your question on the Texas Litigation Accountability Act, the answer is no. Those are civil cases brought by parties, not the state, unless the state's doing something malicious in a civil case. This is a criminal case, so it would not apply.
But I think I still have another charge. I'm not sure, because I wrote this citation on the last day of my probation for the last one, just exactly like this.
Buddy, the reason I asked that is because I got arrested a few years ago, and it was just bogus. They fabricated the charges, and then I go before the DA, and they bring you into this first appearance nonsense. There's not even a judge there or any oversight, so there was no arraignment, no preliminary hearing. They don't give preliminaries for misdemeanors.
No, they're just having you there to cut a deal.
Exactly. Isn't that administrative?
Process right.
No, it's extrajudicial. See, the problem they have with doing things that way is this. They are compelling an individual who does not have benefit of legal counsel to meet with the person who is prosecuting them.
Yes.
Okay? That's a violation of your rights. They're forcing you to engage in conversation with the person who is prosecuting you. Okay? What's the first thing your lawyer tells you about talking to the people prosecuting you? Don't.
Exactly.
Yet they're compelling you to come in and have meetings with these prosecuting attorneys as if it's A-OK, simply because you're going to have to act as your own attorney.
Well, they force you. They also force you under the coercion that you could be arrested. But when you walk out of the meeting, you find out you never had to be there. That's the bits of it.
Legally speaking, you didn't, because there's no law that allows them to order you to do that.
Right. So I sued the DA for malicious prosecution because they dropped the charge before it even got before the judge. And they waited to the last minute. I show up at the court and the DA motions to dismiss. maybe come all the way to the court, and they knew they were going to dismiss it days before or weeks before. But when I sued the DA's office, the judge keeps quoting this case called Imbler, that he's got prosecutorial immunity.
Right.
And that's all he's saying. He's not
Right.
saying a damn
That's
word about
why
anything
you
else.
don't sue the prosecutor, you sue the cop.
I did. The cop case is going forward just fine.
Right. See, the only way you can sue the prosecutor is if the prosecutor lacked jurisdiction in the first place. He can't be acting as a prosecutor if he never had a legal basis to act as a prosecutor, or he actually committed a crime in the process of prosecuting.
Can't you go after them too if they don't have probable cause to charge you to begin with?
You can go after the cop, but you can't go after the prosecutor. There are
Except for
only
my
very,
case.
very, very limited instances when you can go after a prosecutor. However, those are the elected county and district attorneys that you can't go after. In Jane's case, this is a city attorney, and the city attorney is not covered by the immunity that extends to either of those two elected officials.
Hey, Eddie.
If it was the county attorney, can't the immunity still be defeated?
Say that again?
Even if it was a elected county attorney, isn't there a way to defeat that immunity as well?
Yeah, if they're doing one of the things I described, which is committing a crime in the process of the prosecution, or they never had any valid jurisdiction to pursue a prosecution in the first place. And valid jurisdiction is not the same thing as actual probable cause of a crime. Right. Valid jurisdiction means this was never a crime to begin with. There was never any legal authority to treat it as a crime. And yet they attempted to fabricate a crime where none existed. You know what I'm saying? That's very, very different from him simply having a crime and then dismissing it after the fact, or not having enough evidence to go through with it, or whatever other reason they may see to dismiss it.
Okay.
But if they're taking the word of the cop and not double checking it, that gives them immunity. They don't have to double check it. They can just prosecute it.
They
Yeah.
always take the word of the cop. The question is, can you prove the cop was lying?
Absolutely.
Okay?
I've already done it.
Or did they have the evidence to show the cop was lying? Now, the question there is, even if they know the cop is lying, are they obligated to dismiss the case immediately? See, there's the rub. What are they required to do versus what can they do?
Well, wouldn't they be required to dismiss the case if it's
He did
found that
dismiss the case. He just waited till the last minute to do it. He inconvenienced the defendant before he did it. But the question is does that take away his immunity? The judge told you the answer is no. So you can't sue him for inconveniencing you.
Well, this is where it comes back to this setup where they coerce you to come in. They know there's no legitimate charge, but they offer you a plea deal to see if you're dumb enough to take it.
Yeah, and that's part of what they do. But that right there is a prosecutor that's not seeking justice. They're seeking a conviction. That's how, and so what you do in that thing is you make note of that and you hold it over their head at election time. You make a very big public noise about it so that they can't get reelected to that office. That's how you have to deal with that when it comes to the prosecutor. But it does not in any way, shape, or form protect the cop who knew he didn't have a case and didn't have evidence and didn't have anything to make the allegation with in the first place.
Now, you said elected.
The prosecutor threw the cop under the bus. Your only job at that point was to put the bus in gear and drive over his fucking ass.
I did.
Well,
okay.
Like in my case, though, they knew they didn't have all the elements of the charge to convict me of the crime that I was charged with. So they knew that the whole time that they were prosecuting me. And now that it's gone in my favor, that nullifies my attempt at getting a malicious prosecution claim.
No, you could still sue anyone in the chain except the prosecutor. The only way you can sue the prosecutor is if you can show the prosecutor acted in direct violation of law to keep the case alive. That means they fabricated evidence, falsified documents, lied to the court, etc., etc.
Well, I got them doing that. Both her and the deputy prosecutor had lied to the court, and she had attempted, like I mentioned, to get exculpatory evidence deleted.
Right. Now that again is tampering with evidence, and she had a legal duty and a moral obligation to not do that. and her actions themselves are a crime in the state of everywhere.
Right.
Everywhere it's a fucking crime to tamper with evidence in a case. Okay?
Okay.
So now, while that may subject her to criminal penalties, now a court's got to decide whether or not that takes away her immunity from suit from you.
Right.
And the only way you're going to get an answer to that question is to try it.
Right. That's what I'm working on. I have my rough draft to my complaint because I'm going after the officers as well. And along with, I'm going to attempt at getting the city court judge as well for violations of my rights because he violated my due process and he didn't even let me speak at a motion to dismiss hearing that I had filed. He pretty much told me that the only reason he called me in and had a hearing was to tell me that my motion was being denied. He didn't even let me present my case or anything.
Okay, you have an even harder problem with judges.
Yeah, I know.
The only way you're going to be able to sue that judge is if you prove the judge never had any jurisdiction of any kind. And that isn't just subject matter. That's any jurisdiction of any kind. Okay?
Well, he illegally attempted to hold a jury trial in that court, and
that's a separate issue.
He was still
acting in his judicial capacity. Now, he may have violated the rules of judicial conduct and state law, but that does not automatically give you a cause of action against them for it. It may allow the state to prosecute him and remove him from the bench, but it does not necessarily and automatically give you a civil cause of action to sue him with.
Right. Well, in city court, when you request a jury trial, if the alleged incident doesn't happen in the city, then it's a violation of your Sixth Amendment rights because they have to pool jurors from the geographical area of the alleged incident. And the judge in my case was illegally attempting to hold a jury trial in that city court when my case should have automatically moved to the higher court when I requested a jury trial. And he even...
Okay, now that may be a different thing. See, there you go. If he didn't have jurisdiction in the first instance to do anything related to that case because territorial-wise it wasn't within his jurisdiction to handle.
Right.
That might be what you need. That's an argument you need to make, for sure.
Yeah.
The judge never had jurisdiction for any type of judicial act because this case did not occur within the jurisdiction of his court.
Right.
Or the offense did not occur within the jurisdiction of his court.
Right. And he actually prevented me from bringing my evidence into the courtroom. I had a laptop with me that had everything on it so that I could present my case effectively, and he prevented me from going and taking it into the courtroom or anything. I was forced to leave all of my stuff out in the lobby.
Yeah, now you know why attorneys only carry hard copies of everything into court.
Yeah. Well, I had hard copies with me along with my laptop, but it's extremely biased and unfair to the pro se litigant there.
Yeah, well, that's the game plan. It's always been the game plan.
Yeah.
It's how they.
Eddie, how do you feel about exculpatory?
What do you mean? How do I feel about exculpatory? I'm all in favor of exculpatory if you've got it.
Well, no, sorry, I didn't mean to cut you off. So the exculpatory evidence, if a DA ignores it or suppresses it, and I'm trying to understand the difference. If he knows there's exculpatory evidence and ignores it, is that one of those violations you were talking about?
Yeah, that's prosecutorial misconduct because it has an obligation to turn that over to the defense.
And it's a Brady violation.
It's absolutely a Brady violation.
Well, I handed over exculpatory evidence to him in that, coerced meeting, and he walked out of his...
Wait a minute. You are talking two different things here.
Okay.
You're talking about exculpatory evidence in possession of the prosecution that the defendant does not know anything about unless it's disclosed, versus evidence in possession of the defendant that contradicts the case against them. Okay? One, the prosecutor has an obligation to act on. The other, he does not, because that's a fact issue that can be challenged at trial. He may try to say your exculpatory evidence isn't really exculpatory, and here's all the legal reasons why. It's like someone making a claim of self-defense in a shooting or a fight. Okay? You can make that allegation as a defendant all day long. You can offer up your video proof of it and everything else. That does not require the prosecutor to automatically drop the case if he thinks he can make a case that shows your video or evidence doesn't show what you think it shows. That's completely different than the prosecution having evidence that they know spoils their case and they do not divulge it to the defense. That's a completely different animal. So don't conflate the two.
Okay, what if he already had that evidence and all I was trying to do was point it out?
Again, if he can make the argument, if you're aware of the evidence, that's all he's obligated to do. He's not obligated to agree with you that it proves what you're claiming it proves. If he thinks he can make an argument that it proves something else, he has the opportunity to take you to court and do that. What he cannot do is not give you that evidence one way or the other.
Okay.
Now, Miguel, you were going to say something earlier and you got interrupted and didn't finish. So what were you going to ask? Hello, Miguel. You still there? Okay, I guess not.
Donna put the making and meeting objections in the chat. The download.
Yeah.
I tried to get it, but they wouldn't let me have it.
Well, unless you actually have it in the little booklet form, it won't be as useful. Because like I say, the little book is tabbed. And all you got to do is open the tab for the type of objection you want to make. And there's the actual legal language for the objection. And here's all the things that you need to know about when and why you want to make it. It's an extremely useful little book. And like I say, I've still got several of them that Robert Fox gave me a whole bunch of them back when.
I'll take one.
Well, I don't know where they are. They're in here somewhere, but I'm not going to get a chance to unpack them because I'm getting forced out of this house and I'm going to have to go move somewhere else now. I just don't know where it's going to be yet.
When?
Well, they wanted me gone in 90 days, but if I don't have money in my pocket to do it in 90 days, that ain't going to happen whether they like it or not.
Well, I thought your attorney was going to look into whatever your landlord was doing to you. I mean, it's not your fault what's happening over there, is it?
No, I said I may need to get an attorney to look into it, but I haven't done that. Not yet, anyway. Oh.
Eddie?
Yeah.
So what if you challenge?
Say again?
So what if you challenge the complaint is missing in trial, and then they sub you the complaint?
Wait, if you challenge what is missing at trial?
The complaint.
Okay, explain to me what you mean by missing.
The lower court, they did not have a complaint when they were prosecuting us.
They didn't have a complaint when they did what?
When they were prosecuting.
Then how did they prosecute?
They tried to use a citation.
They what?
They tried to use a citation.
Did you object to the use of the citation as the complaint?
Yes, we did, but the judge said move on.
The judge said what?
The judge said move on.
Wow.
Okay, that's a violation of 27.14D of the Code of Criminal Procedure.
Can you say that again?
That is a violation of 27.14D of the Code of Criminal Procedure.
Okay, thank you.
You pled not guilty?
No.
I didn't plea at all because there's no motion.
No,
but the
Kevin.
judge entered the plea.
Kevin, you got the number wrong. 27.14D.
Okay. Thank you.
Mm-hmm.
Yeah, because if they, if you, that's the
Also,
person.
the prosecutor and the judge settled the complaint at trial.
The Code of Criminal Procedure is very clear that if the only way they can use the complaint is if the defendant agrees to it. If the defendant does not agree, they must, by law, make an actual complaint
You mean
and
the citation?
provide the defendant with a copy of it.
Yeah.
Okay.
And that is exactly what is in 27.14D.
What if the judge objects for the prosecutor?
If the judge what?
If the judge makes an objection for the prosecutor.
Explain what you mean by that.
So in trial, the city attorney objected, but the judge said objected for the prosecutor, for the city attorney.
Again, made an objection for what?
The city attorney didn't say it, but the judge made the objection into relevance.
Okay. The judge can tell you that whatever you're saying or doing isn't relevant. That doesn't mean he's making an objection for the prosecutor.
No, he was making an objection for the city attorney.
Did he actually say, well, I'm going to object to that for the city attorney?
No, the city attorney said objection without saying anything else, and then the judge said relevance.
The judge said what?
The judge said relevance. The judge predicted what the city attorney would say.
Okay. The thing is, that doesn't make it an objection for the city attorney.
It is.
That just may have been him clarifying it for the court reporter.
There's no court reporter there. There's a court on no record.
Okay, well, again, did you ask him why he's making statements on behalf of the prosecution?
We asked that, and the judge also said move on.
And did you let him?
We tried to, but he kept training us with content for it.
Well, again, you're only going to get to keep the rights you refuse to give up. If the judge is acting biasly, then you need to call him out on that.
Okay.
Okay? But you need to do it in a proper way. This is a municipal court, right?
Yes, it's municipal court.
Judge, pursuant Chapter 29A of the Texas Government Code, I hereby move for your immediate recusal or disqualification for bias.
Mm-hmm. But the judge, he didn't even read the law. He just ignored it.
Did you say that?
Yes, we were talking about the Texas law, but the only complaint, the judge kept saying move on. He didn't even read the law.
Well, then what you should have done is exactly what I just said. You should have made the argument for his disqualification or recusal under Chapter 29A of the Government Code.
What if he says it is a municipal court and it doesn't matter?
That chapter is specifically for municipal courts. That's why I asked you if it was a municipal court. 29A says very clearly that when a party makes a motion to recuse or disqualify a judge in a municipal court, the municipal court must cease all proceedings. and forward the request for the dismissal or the recusal to the regional administrative judge.
But what if the judge says move on or something like that?
The judge can't say move on. If he does, you object. Objection, judge. By law, you are required to cease everything and file this motion with the regional head judge. Do that, or I'm going to file a bar grievance and I'm going to get your ass kicked off the bench.
Okay. And if you file a motion for discovery and the judge ignores it, what do you do?
Then you go over his head.
Because
But again, make sure you file the proper motion for discovery.
Because we filed a proper motion for discovery, but the judge didn't even look at it. He ignored it. We didn't even get anything back from the court.
Did you get your discovery?
We did not at all.
Then did you file for a writ of mandamus to an appeals court to get it?
No, not yet.
Was this a municipal court of record?
It is a court of no record.
Okay. Which brings the problem I asked you about the other day, Jane, in the email. If it's a municipal court of no record, or it's a municipal court of record in a municipality where there's other municipal courts of record, do they have the power to issue writs against each other? And if there's only one, do you have to go to a different judge in the same court to issue a writ against another judge in the same court? Can they issue a writ against a judge in the same court? These are all the problems that Chapter 30 creates that nobody's given a fucking answer for.
And you said there is a difference between issuing and granting.
Correct. Issuing would be the issuance of an order granting the motion. Okay? That's what they issue, an order. They don't issue the motion or the writ. They issue an order denying or granting the writ.
But the granting is whether or not they'll hear the motion, right?
No.
That's what I read today.
No, the granting, okay. Granting a hearing on the motion is different than granting the actual motion.
That's what I looked up, the difference between the two, and that's what it said. Let's see if I can find it right quick what I had.
Well, it doesn't matter. Guys, we're half an hour past closing of the class here. So, do the homework, please. Take the list of questions in the document and try to fill it out according to the ordinance sections you've also got copies of, and come up with a set of questions that you think would work to show they lack no actual evidence to prove the element.
That wasn't
Okay.
the docs, the docs, was it? It was the one thing you added at the beginning, right? It was.
I gave everybody a copy of the questions. I gave everybody a copy of the ordinance. I gave everybody a copy of the definitions for the ordinance. So, given that, guys, thanks for being here tonight. Have a great night and a great weekend, and I will catch you next Thursday.